Hi everybody, it's Cindy Benavides with Benavides Law Firm. I'm an estate planning and probate attorney in Wesco, Texas, and today I'm going to be discussing the top 3 mistakes I see when someone dies. Mistake number 1 is making too many decisions while you're still grieving. The effect of making too many decisions while you're still grieving is that mistakes are easily made. Number 1, you might not accurately respect your loved one's burial or cremation requests because you're too busy in your own grief to search for those documents that they might have prepared, or to look and call the funeral homes in the area to see if they already had a prepaid plan. You also might be acting without authority. Even though you're one of their relatives and loved ones, you may not be the personal representative or the executor of their estate, and you might be getting rid of assets or paying off debts that the estate administrator should be handling. So how do we avoid this mistake when there are many decisions that we have to make when a loved one dies? I am not by any means telling you not to make decisions. What I'm trying to say is that don't feel rushed or pressured to make these decisions all at once. Some decisions do have to be made immediately, such as organ donation. However, other decisions, such as funeral arrangements, can take a little bit more time, and you can actually talk to the hospital and they'll hold your loved one's remains while you shop around. Look through legal documents to determine where your loved one wanted to be buried and how they wanted to be buried. By taking your time, you're able to evaluate your loved one's assets and debts and stick to a budget. Once you're done with the funeral arrangements and a sufficient time grieving, then it's time to get together with your estate planning attorney. At the time that you get together with your estate planning attorney, you might want to have that death certificate in hand, and that typically takes at least 10 days. So don't feel the need to rush over to your family attorney or your estate planning attorney right away. Take that time to grieve first. The second mistake I see is I'll have individuals who have withdrawn money from bank accounts or have taken possession of assets just because they have the power of attorney. The effect of withdrawing money illegally through a power of attorney post-death can result in criminal prosecution. So how do you avoid criminal prosecution if you need to pay for funeral expenses? Well, just to clarify, powers of attorney are not effective post-death. Powers of attorney are only effective during the life of your loved one. As soon as they pass away, it is no longer legally binding or effective on any financial institutions. So by walking into a financial institution with the power of attorney when you know your loved one is dead, that is fraud. It is a crime. Please don't do it. Instead, what you should be doing, you should be looking to speak to one of the bankers at the financial institutions of your loved ones and asking if there are pay-on-death beneficiaries. You will need the death certificate in order to get to that next step. Another option, in order to take possession of assets such as real estate, you can look to see if there were any enhanced deeds that were prepared by your loved one, such as a transfer on death deed or a ladybird deed. If there are no such documents, then look for a will. If there's no will, then at this point in time, you need to be working with your estate planning attorney to figure out the next steps. There are some exceptions to this particular mistake. For example, if you are the spouse of the deceased and you have a joint account with them, then of course you're going to be allowed to continue on the account and withdraw money. Even if you are not the spouse, but you happen to be a joint holder on that account, then of course you're going to be able to continue as long as you are a joint owner with rights of survivorship on that bank account or on that asset. The other way around this is, as mentioned earlier, speaking to the financial advisor on that particular account to determine if there was a pay-on-death beneficiary for the account and if you happen to be that pay-on-death beneficiary. Mistake number 3 is not notifying Social Security Administration immediately after the death. The mistake that I see people make is that they assume that the funeral director has contacted or will contact Social Security Administration to notify them of the death of the loved one. What is the effect? The effect of not notifying Social Security Administration immediately is that they may still continue to cut checks to the account that's associated. If they're continuing to cut checks to that account, those checks post-death will be required to be reimbursed back to Social Security Administration. So how do you avoid this problem? You need to do 3 things when you call Social Security Administration. The first thing you want to discuss with the agent from the Social Security Administration office is to confirm that they know that your loved one has passed away. The second thing to discuss is whether or not you need a follow-up appointment to go over survivor benefits for the surviving spouse or for any children of the deceased who are under the age of 18. The third and final thing that you want to discuss with the Social Security Administrator is whether there are any lump sum benefits that can be claimed by any of the beneficiaries of the deceased. A good estate planning attorney will know all of this and more to help guide you. If you don't have an estate planning attorney, please reach out to me, Cindy Benavides at Benavides Law Firm. You can call us at 956-854-4363.